Welcome to Criminal Law Unfiltered.
Hello, everybody, and welcome to the very first episode of Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of Helfend Law Group. He's worked exclusively as a criminal defense attorney in Los Angeles since 1984. And with more than 40 years of courtroom experience, more than 4,000 criminal cases under his belt, he's known for aggressive and strategic defense in serious state and federal cases. I'm John Lieberman, and today we're talking about what murder defense actually looks like in real life, not on TV. But before we get into it, let's take a minute to kind of get to know Robert and his background. This, as I mentioned, is episode 1, Murder Charges in Real Life, what TV gets wrong about criminal defense. And it's good to see you, Robert. How are you?
Good. How are you?
Doing well. It's interesting to me. You've been defending people now for more than 4 decades. What drew you into this line of work?
Well, you know what? Criminal law is not as much paperwork as other areas of law. It's basically thinking on your feet, and just like this interview, thinking on my feet. So I'm good at that. I'm good at convincing people orally that I'm right. And that's really what criminal defense work is all about. It's your personality and not so much, can I persuade you in writing? So in criminal defense work, you file a motion, opens the door for you, but it's what you say is what wins the day.
Right. And they always say, right, in murder defense, you only need one. You only need one juror to side with you, to like you, to agree with you, right?
Correct. I got all 12 last summer
Wow.
on a murder case.
So how did you do that? Tell us a little bit more. How did you convince all 12? Because you would assume if a case goes to trial that the prosecution believes they have a pretty strong case. How do you get all 12?
Well, I don't give a shit about what the prosecution thinks. That's number one. Number two is they should understand when I tell them, I don't think you have what you have, they should consider dismissing the case or giving me a number that my client can live with so we can walk away. And that's really what happened. And that's what brought us to trial. But, one thing you need to understand about any kind of a criminal case is it's not about the truth. It's never about the truth. It's about evidence. And there's a difference between evidence and the truth. So, and that cuts both ways. I mean, and you can see conspiratorial issues with the police, not necessarily with the police and the DA, but maybe, as well as the defense. You can spin a piece of evidence any way you want. So it's about the evidence. And so I had the evidence in that case, I felt, and I could go on forever with that.
No, it's really interesting what you said, because I think that the nuance, right, is that not guilty from a jury does not necessarily mean innocent. It means that the prosecution did not prove its case beyond a reasonable doubt, correct?
That's one way to put it. But I would also say that if the jury found him not guilty, then it didn't happen, right? So he didn't commit a crime, did he? Okay, so, but yeah, in a certain sense, that's correct. He wasn't guilty of what they said he was guilty of. And the key to winning a case, and winning a case means your client didn't get convicted. So that could mean it's a not guilty or a hung jury. Like you had said, you only need one. It's really crucial to pick the right jury. And in that case, I knew I had the right jury. I had public defenders walking in during the trial. During a break, they would do their case and then lean down to me and say, "This is a great jury you have." And I would say, "You're damn right." And that's, and so the key to the whole thing is crafting the correct questions that you're asking potential jurors, so you get people to that are aligned in thinking like you are. So it's two things that you want in voir dire, which is, it's called voir dire. That's the questions you ask a jury. But two things that you do is, two things. When I say two things, this is the way I believe it to be. But one of the things you want is you're letting these people who are in this room know the theory of your case as you're asking them. You're telling them, when do you think you could use deadly force, juror number one? When when would you think that it's okay to use deadly force? Under what circumstances? And then, if your client has prior convictions, which a lot of my clients do, is you have to ask them things like, what do you think? What if that situation where you gave me you said person A can use deadly force, he or she would be justified in using deadly force. What if I told you that person was prohibited from possessing whatever deadly force they use, be it a knife, a club, a gun? What if they were prohibited from using deadly force? Would that change your analysis? And so, you have to find people that will put that aside, because sometimes you have people, who are involved in a homicide and they have like a prior felony. So you have to get past people's knee-jerk reactions in cases. You need to know what the knee-jerk reaction is. And in a murder case or a homicide, if somebody who uses a weapon, if you're I learned this by just kind of casually speaking with people over dinner. "Oh, what's your latest case?" "Oh, well, I've got a homicide. Let me just tell, and this is kind of what happened." The knee-jerk reaction is, "Well, what does he have a gun for? He's not supposed to." That's a good point. Thanks for telling me that. And because now I'm going to make sure I don't have jurors that feel like you do. Because if you were coming into my jury, you'd be off. Okay, so that's the key. Boy, did we go on a tangent.
No. It's super interesting. Bottom line, your work starts way before you get, to trial, obviously. And we teased it at the top of the show. So I want to kind of dig into what TV gets wrong about criminal defense. And as you know, I worked at America's Most Wanted for many years. So we got to see it kind of up close and personal, that it's nothing on either side, nothing like it is in TV. So I'm going to pose the question to you. How are real life murder cases different than what we see on shows like Law and Order, Dateline, etc.?
Well, the courtroom drama is never the same that you see on those kind of cases. You don't have, well, first of all, you don't see people on the witness stand getting emotional like that. So you can say, they're lying, or they're telling the truth. People can get, honestly, a courtroom has more consistent liars than any room that you could ever be in. Okay? Just people come and lie their ass off. So you have to just be ready for the lies and not get emotional yourself. It's it's good to try to stay neutral so that the jury doesn't despise you. I know friends of mine, colleagues of mine that don't care about that, and they just get in there with a chainsaw, with uh, with a machine gun, and they just fire away, and doesn't matter if they're getting mad. I try not to get pissed off. I mean, I did do that. Um, I mean, many, many, many years ago, I had a trial with actually who's now a good friend, colleague of mine. I had a trial with him, and it was a not guilty in like 30 minutes or something. I don't remember. It was a felony trial, but so we talked to the jurors in the hallway, and juror number 6, I think it was, comes running up and looks at me and says, "We found your client not guilty, but you're obnoxious and condescending." And I, oh, yeah, I don't know how to take that. I mean, I got the not guilty. So, okay, lady, I'm not obnoxious and condescending in the hallway like you are to me now. So I'm sorry, but
Can you talk, Robert, about how, TV makes everything look super quick? So like in an hour episode, you have the suspect arrested, you have a DNA match, they're at trial, and they're guilty within an hour episode. But can you tell us about kind of what's the real life kind of timeline in a murder case that you see?
2 to 3 years. There's just a lot of evidence. You have to make sure you have all the evidence. You have to make sure you have all the evidence the prosecution has. So you got to make sure you're aware of what they're going to put on as evidence in their case. And you also need to look at the evidence to see whether or not you could use some of that evidence. But there may be other things that they haven't given you that they're not going to use, which actually will be helpful to you. For instance, the way things have evolved over the last, maybe 10 years, probably 20, but really focusing in on the last 10 years is, social media is the way that that police crack a lot of cases. Maybe not crack them, but they use it as corroborating evidence.
Mm-hmm.
And so, it's so when they get your chats and you've said, "Yeah, man, that was really great the way we smoked that guy," that's kind of problematic. So you're going to have to deal with that. And but I'm finding like I have a matter right now where the prosecution is taking text messages from my client and somebody else in this case, and and they've created like a sentence out of it. "See, your client is good for this." But if you read closely, you'll see that you took text messages between August the 8th and August 22nd and made it a sentence. That you've created the sentence. That's not what my client said. You've taken it out of context. So I told the D, I need this. I need all the raw data. I need all the text messages. And the prosecutor actually said, well, we wouldn't have taken out things that were irrelevant, And so I had to tell this person, I'm not relying on you to give me what I need because I can't count on you. Okay, I'll be the judge of the context and I'll do it. So we need all the text messages. So yeah.
No, it's interesting. So let me ask you this, Robert. We have a few minutes left. Let me ask you, you've spoken a lot about evidence. How important is forensic evidence these days? Obviously, you see on TV DNA. How important is that in your cases and for your clients?
Well, it cuts both ways. Jurors tend to want forensic evidence. They want to be able to know that they're right. So DNA evidence, it depends what kind of case it is. DNA evidence in a murder case may apply and it may not. I mean, if some person shoots somebody at, medium range or even, from 20 feet away, what is the relevance of DNA evidence? So DNA evidence is important in sex cases. If your client's saying, I wasn't, it wasn't me, DNA evidence is important. So a lot of the questions that you've posed today, there is no cookie cutter answers to these. Every case is on its own and lives and dies on the merits of the evidence. And evidence in every case is different. So I can't say what is important on a DNA evidence and with the DNA evidence and what is not important. It just depends on the case itself. And that's why one of the reasons why criminal defense has always attracted me is because every case is different. There's not a cookie cutter case. It's not like certain crimes. I know that certain lawyers, they like to do different types of criminal law, but the crimes that they do are very cookie cutter. So if you plead guilty, you're getting this fine, you're going to this school, so anyway, that's why I went and I like criminal defense work, serious criminal defense work, because it's not cookie cutter.
So let me ask you this. On TV, obviously, these cases always end with dramatic trials, as you alluded to. But the reality is, in real life, that's not the case, right? Many cases settle, etc. I mean, in your experience, is there, and I know there's not a cookie cutter answer, but would you say most of your cases go to trial versus most settle? Or again, it just depends on the individual case, right?
Well, if I could say that most cases do not go to trial because, the prosecution has a picture, and the picture is of a hand, and that hand is in a cookie jar, and the hand has the client's name tattooed on the wrist. And so you have to take that kind of evidence and show your client and go, this is kind of problematic here. Isn't that your hand? So we need to figure something out here. Why did, and so there are so many different ways to help somebody out. If you come to a situation where you realize you're not going to get the person out of it, let's mitigate this. Let's make it so that they don't go to jail. Let's see if we could get somebody what we call in California mental health diversion, because obviously there's issues, and let's explore that. So I mean, I always try, if I'm not going to go to trial on a case, to number one thing is to try to get somebody out of a felony, and or to be able to reduce it to a felony somewhere down the road, and make sure you're not going to jail. So.
And lastly, Robert, if someone who's watching this, if their loved one has been arrested for homicide, what should they do first before they say anything to police, media, family, anybody? What should they do?
Well, they shouldn't say anything to the police. And they should, if they can afford it, they should hire, criminal defense counsel that does homicides. If you have the resources to bail your loved one out, I would bail them out if you can. But in California, that's a large number. Not all my clients can do that. So it just, you don't want to make any statements to the police. So, and there's many reasons for that. We could talk about that in another episode.
Yeah,
there's many reasons why. Yeah,
we'll definitely dive into all the reasons why If you're arrested, you generally don't want to talk to anybody. Well, listen, Robert, this was very enlightening. Thank you so much, Robert. Very enlightening. And thank you all for tuning into this episode. If you or someone you care about is facing a serious criminal charge, you can visit robertmhelfend.com to learn how Robert and his team can help. And be sure to like, leave a review, and subscribe so that you don't miss the next episode. Thank you so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.